When you work with people, things will always go wrong. It's just how it is, no matter what steps you put in place to protect yourself. So you need to know you're covered. People often don't realise this, but having a contract in place between you and your subcontractors doesn't just demonstrate to HMRC, or indeed any eyes of the outside world, that they're genuinely self-employed. No, they also set clear boundaries between both parties about who's responsible for what when the proverbial hits the fan. It's no different to when your clients ask you to sign into those 100-page contracts. They want you so tied up in knots that even when it's not your fault, it is. I'm not saying your contract with your subcontractors need to be like this, but why should you be forced to carry the baby when it's negligence on their part? We had a scenario where the commercial protection within our contracts was called into action. One of our clients, a 35 million groundworks company, had a situation where a subcontractor had acted negligently and pulled a wheel from a tipping dumper. The anticipated cost of this damage was in excess of £700, and naturally the client wanted to put the cost of this back onto the subcontractor. A deduction was made from the subby, who in turn kicked off like a kid having a tantrum in the chocolate aisle in Asda. They started with the unlawful deduction claims and went as far as the false self-employment threats. A lot of the time, that's enough to drop the case in many business owners' eyes. It's aggro, and most people aren't sure what they're actually covered for, so it's not worth it. Not for our clients though. We directed the subby to his signed contract, which included the following clause. If, in the performance of the services, the subcontractor or any substitute of the subcontractor causes any reasonably foreseeable damage or loss to any tools, plant or equipment provided by the contractor, the subcontractor agrees that they are to be held financially responsible for any costs in replacing or repairing such damage. The contractor also reserves the right, at their discretion, to deduct such costs from any payment due to the subcontractor to recover the cost of any damage or loss. We didn't hear back. Not having a contract in place leaves everything open for interpretation and means you're probably not covered in these instances. We go to great lengths to make sure we've got the relationship between you and your subbies nailed for two reasons. Number one, we want to make sure that how you work with your subcontractors is genuinely self-employed and we aren't claiming on our insurance policy. And number two, your subcontractors are responsible and accountable for their own actions. If you're worried about your risks and you want to work with the self-employed subcontractors for the long haul without malicious intent coming to trip you up down the line, just have an open chat. With our years of know-how, we can offer the best advice for you and your business, protecting you not only from HMRC, but negligence on the ground. Thanks for watching.